Do I have to go to court to sell a house in probate in California? What a great question that is. Well, we're going to get into that next. Welcome back to the channel featuring California's leading probate real estate team. I'm Brendan Mohr, realtor and certified probate and trust specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary, as well as a registered and bonded legal document assistant specializing in probate work in California.
Now, please like this video, subscribe right now. What a no-cost probate service. Well, every day we help people save thousands of dollars and eliminate headaches with our one-of-a-kind probate administration service and real estate listing combo. If it's in California and real estate needs to be sold, you may qualify. So please reach out, even if you've started your probate with somebody else or on your own. Our info is on the channel in our About section. We love your calls, texts, emails, and comments. Now let's get into it.
So Brendan, why don't you tell us, when is court involvement required?
That's a great question. So court involvement is required when the personal representative has only been granted limited authority from the court. So during that process, once you accept an offer, there's a whole process after that. It could be months later, you're in front of a judge and the judge has to say, okay, I approve the sale, or they don't approve it. And we have a whole video on what's called limited authority or a probate sale with court confirmation required. But that would be a case where you do have to go to court to sell a house. But that's not always the case, is it, Bill?
No, not always the case. In fact, most probate cases in California, most of them never do go to court for a confirmation hearing. And that's because most probate cases have what's called full authority under the Independent Administration of Estates Act, also known as the IAEA. And when you have full authority under that act, which most probate administrators and executors do, no court confirmation hearings required. The only thing that is required is you have to give notice to all the heirs. They have to be told what the terms of the sale are, the sales price, etc. And as long as they don't object to it in writing or go to the court and object, the sale is going to go through pretty much like a regular escrow, especially on the selling side, or the buyer side, excuse me.
And that special notice called a notice of proposed action that doesn't exist when it's limited authority. That's really the judge's job to confirm the sale. But as the personal representative, you essentially get to confirm the sale and the heirs are approving of it at that point using that special form. So really, you don't have to. Now, if you have full authority though, then one of the heirs objects.
Oh boy, that throws you back into the same boat you'd be in if you had limited authority, and you're gonna have to go through the court confirmation process.
Yeah, and now one thing a personal representative wants to do as their duty as the personal representative is act in the best interest of the estate. And usually if you're doing that, you're looking out for the best price and the best terms on an offer. If it looks like you're self-dealing, selling this property to a friend, some investor called you and said, hey, I want to buy this house and you're selling it really cheap, things like that, then you're probably going to get some objections, and then it is going to go to court.
And in addition to the heirs objecting, if you take an offer like that to court, the judge may come in and say he's not going to confirm an offer like this. You never know.
So I'd say if you want to avoid court, which is pretty easy to do, there's certain things that you want to do. One of those, you want to hire the right probate professional, and that can be an attorney, that can be a non-attorney probate administration service like what Bill does for a significant cost savings. Both of those would really help because you have a professional going through and helping to advise and all that. Communication with heirs, right?
Super important, super important. I mean, you always want to keep the lines of communication open because really, I mean, I've been involved in probate work for 40 years, and almost all the time when a problem comes up, it's usually because of the lack of communication. One or more of the heirs didn't understand something, or they didn't get notified of something. It's communication. It's just key to keeping everything running smoothly and the elimination of, if not most, all problems.
And not only good upfront communication, but good communication through the process. Probate can be very confusing to people, and as a personal representative, a lot of personal representatives are very responsible and maybe even know real estate better than maybe some of the other heirs or beneficiaries. Your family may not know about all of that. Plus, they're probably not in contact with your probate professional. So sometimes there's just misconceptions. And with good communication, you can help alleviate that, avoid objections, avoid court. But another great way to avoid court is one, to actually be granted full authority.
Yes.
And a lot of that depends on who you choose for the personal representative.
Yeah, it actually does, because it matters who's going to act as a personal representative, because a personal representative, number one, obviously you want somebody who's trustworthy. That's important. But you really want somebody who is organized, quote, has their act together, also is in a good financial position, because there's times when the personal representative has to post a bond. And if he does have to post a bond, it's almost like qualifying for a loan. You have to have a good credit. The bond companies prefer that you own your own home. They're looking for somebody who's trustworthy when they're going to sell you a bond, a probate bond, so it's very important. And also, you want a personal representative that's going to always act in the best interest of the estate. Someone who's going to put the estate above their wants, needs, and desires. That's really what you want.
That'll keep you out of court.
Yep.
So yeah, if you don't want to go to court to sell a house and probate, there's some great things you need to know there. And another thing that'll probably help you is if you hire the right probate realtor. Everybody knows a realtor, but not everybody knows a realtor who really knows probate. And a specialized agent in probate will do some things that may actually help you stay out of court, that helps objections not occur.
Yep.
and further problems down the road.
I've actually worked in a number of probates in the past where the family that I'm working with doing the probate work, they have a family member who has a real estate license, and they just basically list the probate home with them because they have a real estate license. And I can't tell you how many problems develop because of that. And it goes back to just what Brendan was saying. Everybody knows a real estate agent, but very few people know a real estate agent that knows probate. I just can't emphasize how important that is, that you get a real estate agent that knows probate, like Brendan.
Oh, well, thank you, Bill. Anything else you'd like to add to this? Keeping out of court and selling it without having to go to court.
Yeah, I mean, the only other thing I just would add is that if you do end up having to go through a court confirmation process, and you mentioned this before, it's longer, it's going to add time. Number two, it's going to add costs. There's extra costs. There's extra filing fees. You got to publish in a newspaper. There's extra publication fees. And on top of that, especially if you have a full authority situation and you have an heir that objects that forces you into a court confirmation, it's likely you're going to lose your buyer. They may not want to wait around for that process to go through. Those are the only other things I'd just like to kind of mention about that.
Yeah, you want full authority. You want to not have to go to court, to sell it. That tends to be the best outcome for the estate. Now, we mentioned several different things, and there's so many different videos I could lead you into to help you learn this process. I'm going to mention a few here. There's a great video called How Much Does Probate Cost in Sacramento that really covers all of California, but it's a little bit more Sacramento focused. But that helps you decide who's going to probate your estate and how much it's going to cost you, from doing it yourself to a great service, a cost-saving service like what Bill provides, a non-attorney probate administration service, or a probate attorney. And we have another great video called How to Hire a Probate Realtor, where we give interview questions for hiring a realtor in probate and a downloadable list. And that'll really help you decide on who you hire, because like we mentioned, everybody knows a realtor, but not everybody knows a probate realtor. It is dramatically different, and you will know if a realtor is telling you they know probate when they really don't. But I'd like to link this next video because this is the one you really want to watch. California Probate Real Estate Sales Explained in 5 minutes. It's actually less than a 5-minute video. It goes from start to finish for a sale where no court confirmation is required, where you can sell without going to court. That's going to be linked next. Right over my face.